Okay, General, I think everyone's on. If you want to go ahead and get started.
All right, well, let's see if I can figure out how to make this newfangled stuff work. Can you see me? Can you hear me? Bethany?
Yes, I can see you and hear you.
All right.
You're ready to go.
All right. Well, good morning, everyone. We're here today to talk about House Bill 6, the ongoing litigation. As many of you will recall and have written about, the state of Ohio filed a lawsuit in Franklin County Common Pleas Court seeking remedies available under the Corrupt Enterprises statute. And I was going to say last month, but here we are in February. In December, we won a preliminary injunction preventing the nuclear bailout fee from being charged customers here in Ohio. That was set to begin in January, so that's a big win for consumers. It's also frankly good for the economy because the manufacturers and large users of commercial users of electricity would have had a very significant financial impact that would have impacted their ability to grow and thrive, particularly in this coronavirus economy. Today, we're here to talk about a second motion for a preliminary and permanent injunction that we filed in that action, and that's to address a separate issue from the nuclear bailout. I'll use that term, which is what's known as decoupling. Or the conservation service or support rider. For those of you who are fluent in PUCOEs, basically what decoupling does, it's very sophisticated and clever little arrangement. But what it did in House Bill 6 is it basically locked in the profits of 2018 into future years and allowed First Energy to recapture any profits they might lose through operation of the markets. A for-profit company, probably as a matter of morality, should not be able to guarantee its profits against the marketplace by operation of law. But be that as it may, we felt that that was the fruit of the corrupt enterprise that was outlined in our complaint, and we asked under the statute that the court restrain that government decision to allow that CSR, the Conservation Support Rider, from being applied in 2021. That amount of money we are estimating is at about $102 million for 2021. And of course, there are future years where the calculations will be made and it will be a little bit different each year depending on what the actual numbers are. But 2021 gives you a sense that we're not talking chicken feed here. The purpose of the news conference is to announce that we have reached an agreement with First Energy where they're going to give up the CSR. Later today, perhaps it's already happened, they will be filing an application with the Public Utilities Commission of Ohio to set their CSR to zero, basically meaning that they will not be able to collect a dime on that rider that supports the decoupling and ultimately guarantees them profitability in spite of market forces, locks in that record high year of 2018. There are a few other things that are relatively technical about the agreement. One is that we are agreeing, having obtained our major pressing goals in the lawsuit, decoupling and the nuclear bailout, we're agreeing to stay discovery and further proceedings in that lawsuit until the federal criminal investigation is complete. Many of you may recall that Judge Brown had previously stayed discovery until March to see what was going on in the federal trial. Having obtained these two very significant remedies for the people of Ohio, we feel content at this point to allow the criminal process to move forward, preserving all the remaining claims that we have under that state lawsuit for the future. But in the meantime, allowing the criminal process to go forward at the federal level. So what does this all mean? When you take the nuclear subsidy and the decoupling remedy that we have gotten today under the new leadership at First Energy, this office and its actions are nearing a $2 billion savings for the consumers of Ohio. That's $2 billion over future years that would have been taken out of the Ohio economy, out of consumers' pockets, and we're restoring the status quo before House Bill 6. I'm really proud of Chip Miller and Jonathan Blanton and the legal team that's been working so diligently on this. I appreciate the governance changes that First Energy has made and the new direction that their new leadership team is undertaking, and recognizing that changes need to be made with regards to the law and the application of House Bill 6. To give you a sense, if we talk about $1 million, let's think about seconds. 1 million seconds is, I am told, about 11 days. So, into less than 2 weeks. 2 billion seconds, as in 2 billion seconds, as in $2 billion saved over the life of House Bill 6 is 63 years. We're talking about a lot of money here. We get a little numb to millions and billions and trillions when we hear the arguments in our nation's capital over the budget. But the fact of the matter is, for any state, $2 billion to come out of its economy is a lot of money. And because of this lawsuit, that money's not going to come out of the economy, and it's not going to enrich these two energy companies. So with that, I'll be happy to take any questions.
Oh, yeah. I'm sorry.
Your first question is from Marty Sladen with the Ohio Capital Journal.
Hey, Marty.
How are you?
I'm doing pretty good.
I've got a lot of questions. I'll just try to stick to one or two. First of all, the governor's getting ready to reappoint a chairman of the PUCO. The former chairman was a former First Energy lobbyist who helped write House Bill 6 that allowed this recession proofing and the decoupling charge. Do you think it's important to appoint somebody to the PUCO who's not, has ties to the same companies that he's supposed to be regulating?
Well, obviously, we're all troubled by some of the things that we've seen, and that process is playing out with the United States Department of Justice. Well, I don't think we know everything there is to know yet. I'm confident that Governor DeWine is going to make a sound decision and appoint somebody to that position who will be independent and a solid leader with expertise in the utility law. I have to say one thing, because I do hear a lot of people saying, well, we need a consumer advocate to be at the helm of that agency. this lawsuit has been a tremendous crash course in just how complicated utility law is. I think that the first criteria ought to be independence, but the second needs to be expertise. Having a good heart and wanting to be a voice for the consumer simply isn't enough to lead that regulatory agency. We need to have somebody that understands it, or the people, the lawyers who do understand the intricacies will run rings around the watchdog. And that's not good either.
Your next question is from Jeremy Pelzer with Cleveland.com.
Good morning, Governor. Or not yet.
Thank you.
General, not yet. Wanted to see with the decoupling agreement, does that include a refund for, because decoupling, of course, was implemented in January 2020. Would you seek a refund for what's already been collected, or is this just going forward?
This is a going forward basis. We retain the ability to litigate over that money that had been previously paid. And there's some legal differences between 2020 and 2021. So we felt that it was important to get this thing stopped on a going forward basis. We still have the right to litigate in court after the federal process is finished regarding the past.
All right, so you're planning to litigate, or you haven't made that decision yet?
I think it would be fair to say that we want to see the rest of the facts and have some discovery before we figure out our future progress in the case.
Gotcha. Thank you.
Your next question is from Laura Bischoff with Dayton Daily News.
Hey,
Hey,
General. Going back to the summer of 2019, were you pressured by proponents of House Bill 6 to either block or slow walk the referendum wording? And if so, how did you respond to that pressure and who exerted it?
You know, the only conversations I really recall having from that, I'm not even sure about your time frame. I'm accepting that it was December 2019. I thought it was earlier in the year, but be that as it may, we had numerous conversations internally. I am sure that there were casual comments through the course of time. Everybody's got an opinion and they always like to share it with the elected official. But pressure, no, I don't recall anybody asking me to do anything in particular, and certainly nothing that I would view as pressure.
As a follow-up, do you have any concerns about how Householder paid his lawyers out of campaign money? Is that something that would prompt you to maybe file a complaint with the Disciplinary Council?
Well, I previously filed an action with the Ohio Elections Commission. I believe that the expenditure of campaign funds for the criminal defense in this matter is contrary to law. That complaint is languishing, I'm afraid, in front of the Ohio Elections Commission. And what I'm told is that they feel that they can't go forward because they can't compel, under the Fifth Amendment, Mr. Householder's testimony. I think that's nonsense. And under that idea, we can never enforce any law as long as the respondent or defendant is asserting their right against self-incrimination. Hogwash. We move forward, we prove what we prove. If they choose not to defend themselves or provide additional information that might be exculpatory, that's their choice. But this expenditure seems wrong on its face to me. And I hope that the full commission will reconsider the director's position on this matter.
Thanks.
Your next question is from Madeline Ashley with WDTN.
Hey there. I was wondering if you might be able to speak a little bit on, this all the cities joining together and the impact that this has.
Bethany, I don't know if you could hear that question, but it was garbled to me. If you can repeat the question, Bethany.
Yeah.
Madeline, what? Go ahead.
Can you hear me now?
That's a little better.
Sorry about that. I was wondering if you might be able to talk on, all these cities in Ohio coming together and the kind of the impact that this is having on this situation.
Well, I don't know that it's especially an impact. My office pretty much negotiated this with First Energy, and we're certainly keeping the cities apprised. We are agreeing for the two new cities that want to join the litigation, have a seat at the table. We're agreeing to their intervention. On the other hand, I don't know that that change, their presence at the table really changes what we're doing or what the outcome will be.
Thank you.
Your next question is from Alex Ebert at Bloomberg News.
Good morning, Attorney General. Good to see you. Hope you're feeling well.
Thank you. I'm feeling great.
You had discussed the Fifth Amendment earlier, and my question comes right along those lines. I'm hoping you can tell me a little bit about the balance you consider when weighing pausing your civil lawsuit while the criminal trial is going on, because your civil suit can be a lever to move things forward. What discovery comes out in your case would probably be good leverage for the federal prosecutors and vice versa. So how do you weigh, the timing of getting this action here with the agreement with First Energy against the ability to better build stronger cases, both here and in the federal criminal prosecution? Thank you.
Thank you, Alex. First of all, it's important to remember that there's a stay on discovery currently operating in the state civil case. So we're talking about the realm of what if. We certainly can't move forward on the remainder of the issues without having had discovery first. And I don't have any indication that Judge Brown would see a changed circumstance in March that would allow him to lift that stay. So as a practical matter, we're agreeing to what is already the de facto situation. Secondly, I think it's problematic, and I've talked with U.S. Attorney David DeViller several times about this. I don't think you can use, I think there's a problem when you start mixing criminal investigations and civil work. And I was never interested in doing that. Thirdly, and maybe most importantly, the two worst pieces, the two worst outcomes for Bill and Betty Buckeye are the decoupling and the nuke bailout. Having been able to stop the effect of those takes the worst impacts of House Bill 6 off the table. So I'm content to let the criminal process work for people to be held accountable, and then to move forward on the remaining issues in the civil lawsuit at an appropriate time.
Your next question is from Sean Hegarty at ABC 13 in Toledo.
Good morning, sir. With these dollars taken away from First Energy, what is your level of concern about the longevity and the viability of Davis-Besse going forward for Energy Harbor and for the process in general, and what that could mean to Ottawa County if anything's compromised with Davis-Besse?
Well, first of all, let's look at the facts. When House Bill 6 was debated, incomprehensibly to me, there was no meaningful financial information provided to demonstrate need. After Energy Harbor emerged from the bankruptcy proceeding and became separate from First Energy, Energy Harbor undertook to buy back hundreds of millions of dollars worth of their own stock shares. That's hardly the move of an entity that is cash starved and needs a public subsidy. So we had no basis in fact that was given, at least to the public, to support that subsidy to begin with. Secondly, they seem to have lots and lots of cash to be able to do a maneuver that primarily benefits shareholders and the folks that are the executives of that company that hold stock options. I'm not convinced that Davis Besse is in jeopardy, quite frankly. Now, if we hear that they are, I think that the legislature is fully capable of designing a need-based situation, a need-based remedy. I support energy diversity. We've seen spikes in the cost of natural gas. It's not unreasonable to imagine either a natural disaster or a climate-based issue that is that could end up jeopardizing our electricity supply. So I have no problem with the idea of energy diversity, but if you're going to be meddling in the market for reasons of strategic security of the energy grid, you damn well better make sure that it's actually based in fact and is actually needed. And both of those questions, as far as I can see, are open in the public record with significant data to suggest that they are not.
So am I hearing you say, sir, that from all the information you've gathered now, that you don't believe that the nuclear industry in Ohio even needed a bailout?
I don't have enough information to draw that conclusion. What I do have is enough information to make me question whether the need was real. And the fact that First Energy and Energy Harbor now have historically refused, despite many and repeated pressing requests to provide the financial information, leads me to believe that at best it's an open question.
Thank you, sir.
Your next question is from Andy Chow with Ohio Public Radio.
Hey, Attorney General. Two questions, if you don't mind. One, just trying to make sure I understand something. Are you saying that First Energy is going to file with the PUCO to change its rate plan, to remove the decoupling part of its rate plan?
Technically, they will be moving to set the rate to zero, which will have the effect of eliminating it.
Okay. And then I just kind of trying to get your overall view. What's your take on this decision by First Energy? Should people see this as somewhat of an admission of guilt on their part if they're deciding to back away from this decoupling mechanism that they had sought out in HB 6?
Yeah, I don't think that. I don't think that at all. Remember that First Energy has undertaken a substantial house cleaning. Most of the senior players are gone. Their general counsel, the CEO, the VP for government affairs. I think there's 6, maybe even 8 senior folks that have been sacked. There's a new leadership team in place, and I think that this agreement probably suggests that the internal review that the board ordered and the information that they found has concluded they need to go into a new direction. So I appreciate the fact that they were willing to discuss settling this on a going forward basis. And in fact, this is a permanent change that is countenanced.
Your next question is from Tom Bosco with Channel 6.
Hey, Tom. You may be muted.
Hey, Tom, are you there?
Yeah, thanks. I was muted. Thank you. Good morning. I was wanting to know if you had any concerns with a change coming at the U.S. Attorney's Office with the prosecution of Larry Householder and his acquaintances. Do you worry that there will be a slowdown in that investigation and prosecution? Or conversely, do you think maybe perhaps DeVillers is going to work a little faster to kind of try and wrap this up before he's out of office? Any concerns with that prosecution?
Well, the truth of the matter is, in criminal prosecutions, the timeframe is driven by the defense, not the prosecutor. And I don't think I'm guessing David would be happy to go to trial soon if the defendants wanted to. I don't think it's within his ability to speed this up. With regards to, do I have any concerns about it? I don't think so. Much like my office, at some point I'm going to be term limited out or perhaps turned out by the voters, and we'll have a new attorney general. That doesn't mean all those cases stop. It just means there's new leadership, perhaps new vision at the top. But the career prosecutors of the United States Attorney's Office who are handling this matter are well capable of pressing the matter forward and bringing the case to the jury.
Your next question is from Mark Gillespie with the Associated Press.
Good morning.
Morning.
Has your office had direct talks with Energy Harbor and has requested financial data from them?
Well, at this point, we're adverse in litigation, so we will certainly, we already have some subpoenas out for certain financial information, and once discovery is permitted to go on by the court, we will certainly be looking at financial data, both from Energy Harbor and First Energy.
Your next question is from Dan Shingler with Crane's Cleveland Business.
Hi, Attorney General. Quick question. The 102 million, over what time period would that have been collected?
That's the 2021 number.
Thank you.
Your next question is from Mark Kobach with the Columbus Dispatch.
I think you might be muted. And Mark, let me tell you, while you're finding the unmute button there, I have to give you props. One of the most entertaining and least toxic things I see on Twitter are your out of context court documents. Please keep those coming.
Mark, are you there? Okay, we'll go to the next one. Josh Rutlenberg with Spectrum News.
Can you hear me, sir?
I can.
Yeah, I just wanted to just clear up. So outside of a potential seek of refunds for this is an official settlement on the entire civil lawsuit. Is that true?
No, it's a settlement of the motion for preliminary and permanent injunctions on the CSR.
Thank you.
We're going to go to Andy Chow real quick for a follow-up. Mark is here. He's going to get me the question.
Hey, I appreciate the follow-up. As you were saying, Attorney General, First Energy, that's the decoupling side of things. Energy Harbor is more of the nuclear bailout side of things. With the announcement that you're making today, do you have any message to Energy Harbor to maybe they should rethink what they're doing with the subsidies that can still be coming their way through HB6?
Well, we have the preliminary injunction on that, so there's no subsidy going toward Energy Harbor. I suppose that in the future that preliminary injunction might be lifted. However, legally, the cases for the preliminary and the permanent have a lot of similarities. I'm very optimistic that we will, when we get to the point of a permanent injunction, we will prevail there as well.
We have a follow-up from Marty Schladen as well. Go ahead. Marty.
General, so there's all this money from the decoupling charge, but there's also over $1 billion that's been collected from the distribution modernization rider and other upcharges that the PUCO allowed First Energy and other utilities since 2009. And right as it stands right now, legally, those funds are unrecoverable. That's just money that's out of businesses and people's pockets. Any effort, do you contemplate any effort to get that money back into ratepayers' pockets? And what about the OVEC subsidies that are also a part of House Bill 6, the coal stuff?
We don't have evidence at this point to support that the OVEC subsidies were part of the corrupt enterprise. That appears, as far as I can tell at this early juncture, we don't have discovery yet. It appears to me that that was a coalition widening thing that the speaker may have used to get more people on board with the House Bill 6 coalition, which, as you recall, there was a lot of resistance to House Bill 6. It was a close vote. There was a lot of arm twisting going on and a lot of attempts at persuasion. So at this point in time, I don't see the nexus that would legally give me a basis to go forward on OVEC. Obviously, new facts could potentially change that assessment. With regards to the prior charges that you referenced, going back to 2009, I would ask the General Assembly to pass a statute that allows refunds to happen when a rider or rate setting is determined to be improper by the Supreme Court. It strikes me as fundamentally unjust. However, the law is what it is, and we're stuck with the law until it's changed. And I don't know what remedy there would be other than the legislature, since we have that Supreme Court decision. I think the Supreme Court was probably right as a matter of law, and I think that the impact of the decision is profoundly unjust, which means that means it's a legislative problem, and the legislature needs to correct it.
Thank you.
The last question is from Mark Kovac with the Dispatch.
Apologies, sir, for the technical difficulties, and thank you for your kind words on my tweets. Off-topic question, you tweeted this morning that you're going to run for re-election and not for U.S. Senate. Can you just maybe provide a little more on why you made that decision, why you've decided to run for re-election, not something else?
Well, I won't hide from you that I spoke with Senator Portman in a little more depth about his reasoning. And based on his firsthand accounts, Washington just doesn't sound like a terribly healthy place to go to work right now. But that being said, the primary reason is I asked myself the question where I would have the opportunity to do the most good for the people of Ohio, and the most good for the country. And I've concluded that it makes more sense for me to run for re-election, to focus on this job, that I have greater impact here than I could on the backbench of the United States Senate. And I think this press conference this morning is an example of what I'm talking about. We were able to go to court to try to hold First Energy and Energy Harbor accountable. And we've been successful. We've been $2 billion successful. And, this hasn't been a matter where the PUCO solved it. The legislature didn't solve it. We were able to use the power of the Attorney General's office to go to court and get justice. I just don't see those kind of opportunities for one member of the United States Senate, and I want to fight for the rule of law and for the equal application of justice. Thanks for the question. And thank you, everybody, for joining us today. I appreciate the opportunity to talk to you about these developments. Stay healthy.